Hello, everyone. This is Kevin again with the Worthy Law podcast for May 2019 this time. And today I want to talk a little bit about summary judgment. Summary judgment is a little bit technical. We've been talking about some technical things over the past few months. And summary judgment is another one of those technical things. It is a way to try to end the case, or at least end part of the case, without having to go to trial. It's been around since the early 20th century. Before that, there was really no summary judgment to speak of, but the courts changed the rules back then, especially the federal courts. And then the states followed suit, and now we have this very prevalent motion for summary judgment. You can use it as a plaintiff, you can use it as a defendant. If you're using it as a plaintiff, you're basically saying that the defendant has no evidence in support of his defenses. If you're using it as a defendant, then you're saying that the plaintiff doesn't have enough evidence to prove his claims. So usually you're going to file a motion for summary judgment after a fair bit of discovery has been conducted. A lot of times you're going to do it after the close of discovery, and discovery is that period during which you're allowed to ask formal questions in writing, you're allowed to take depositions and all those kinds of things. So a lot of times after discovery is closed, the parties are going to file motions for summary judgment. And again, the plaintiff is basically going to say that the defendant doesn't have evidence in support of his defenses. And if the defendant files a similar motion, he's going to say that the plaintiff cannot support his claims. So I want to talk just briefly. I know this is a very technical subject, and so maybe not everybody is interested in the details here, but I want to talk just briefly about what the different standards are, because there's a legal standard, and it is that there has to be no genuine issue of material fact, and the moving party has to be entitled to judgment as a matter of law. And this is actually a really high standard. Sometimes I talk with clients who don't quite understand how high the standard is. I have won motions for summary judgment before. I have filed motions on behalf of plaintiffs and defendants that have been very effective. And in one case last year, I won the case outright on a motion for summary judgment. But that's not always what happens. And that's because there really has to be no genuine issue of any material fact. And what that means basically is that there has to be no conflict in any of the evidence. The witness testimony can't be in conflict. The documents can't be in conflict. If there's any kind of conflict there, then the courts are almost always going to let that go. And they should let that go. Sometimes courts won't. You can appeal that, get them reversed on appeal. But for the most part, they're going to let that go. If one witness is saying one thing and another witness is saying another thing, you have to go to trial. That's just how that works. As long as they're talking about material facts. When we say material, that's another way of saying important. So you can't just be arguing about stuff that doesn't matter to the case. There can be disputes about this thing or that thing. You know, did a conversation happen on March 28th or March 29th? Or any kind of factual dispute that you could imagine that doesn't really make any difference. If it doesn't really make any difference whether the conversation happened on March 28th or March 29th, you don't need to resolve that. You can go ahead and enter summary judgment as long as there's no issue, there's no conflict in the evidence with respect to things that do matter. So, you know, with a traffic accident case, I don't really do traffic accident cases, but I like to use them for examples because they're visual, they're easy to understand. Let's say that one witness says that the light was green at the intersection and the other witness says that the light was red at the intersection. And maybe the second witness is not very believable for some reason, but that's still what he's saying. He's saying that under oath. He's giving sworn statements saying that the light was red. And so it may be pretty easy actually to prove at trial that he's not telling the truth, but in most cases, his affidavit alone, his sworn declaration alone, is going to be enough to force the case to go to trial. So That's basically summary judgment in a nutshell. If you are a plaintiff and the evidence is so one-sided in your favor that the defendant really can't defend himself at trial, you don't actually need to go to trial. So you can file a motion for summary judgment, you can save yourself the time and expense of trial, and you can win. And you can also do that just on part of the case. You don't have to win the whole case necessarily. You can do that on one claim or part of a claim or different things. So it's a vehicle, it's a tool that you can use as a litigant to make a little bit of progress in the case. Same thing with the defendant. If a plaintiff doesn't have proof of all the different things that he needs to prove for a claim, you can get claims knocked out. Sometimes you can get the entire case dismissed against you just on summary judgment. So there's a little bit about summary judgment. If you have questions about summary judgment, if you're facing a case where you think that you've got a really, really good case and you'd like to talk with us about summary judgment and maybe whether that's something that might work in your case, feel free to let us know. But in any event, if you made it this far, thanks again for listening, and God bless.